This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
As promised, we're joined now by Todd Lutsky for Ask Todd. This is your chance to ask Todd your questions about your estate plan. So we've opened up the phone lines here at 888-205-2263. That's the number to call in order to ask Todd your questions. The number again is 888-205-2263. Usually we're only able to get 2 to 3 calls in, so make sure you get in line early to make sure that your call can be answered by Todd live on air. Hear that number one more time is 888-205-2263. Mr. Lutsky, how are you today?
I am never better, and you?
Well, was a little confused over the weekend.
What happened?
Well, I wasn't really sure why I needed a Geiger counter.
A Geiger counter?
But then it clicked.
You got it.
Yeah.
Oh, good. I get it.
Let's talk a little bit about... I want to talk a little bit about trust planning, Todd. Is there ever a size estate that is too small for trust planning?
And I think when we talk about potholes, which I know is the guide that we're giving away as we approach the end of the month, this is probably the first one on the list. I really don't want people to think that, my estate's too small to plan. I don't need to worry about it. I mean, I find is it possible to have an estate that's too small? Yes, I guess it is. But I think generally probably not. And maybe here's the guideline. Even if you're single and you have no kids, obviously if you have kids, you're married, you have assets, it can't possibly be too small to plan because there's loved ones that you want to take care of. But let's say if you're single and no kids, you might have some nieces and nephews, you might have some cousins, siblings, people that you are close in your life and you want to take care of. And let's say your assets consist of, I just got a house and,
sure,
and not a lot of other money. To me, that's enough. I mean, houses are big assets that need to get where you want them to go. And you should decide how to do that other than leaving it undone. Because if you have no will, now who gets it? Well, now you got to go to court and let the state decide who's going to get these assets. And that can never be good. Plus, it's going to probate. So, I mean, at least do a will to direct where your assets go. But I don't know if it's if there's just the one that's too small. If you have absolutely nothing, then yes, I guess you don't need an estate plan.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. If you've got a question you'd like to ask Todd live on air, the phone number here is 888-205-2263. That number again is 888-205-2263. That's the number to call to ask Todd your estate planning question. Todd, let me take the other side of that.
Sure.
At what size estate does someone outgrow kind of more basic estate planning needs? When do you start needing something that's more complex?
And that's really a good question, too, because, we know that this estate tax law is changing. We've been talking about it for, a couple years now. We know it's getting closer and closer.
Is it end of next year?
Yes, it's the end of 2025, January 1, 2026. So it is quickly approaching, and that number is going to fall. So the estate tax exemption, let's say, indexed for inflation, it falls to, say, $7 million. And that's after the index. If you're married and you're worth $14 million, you're on the bubble, right? You're on the bubble.
Sure.
It doesn't mean you ever outgrow, so I'll clarify the language a little. When you talk about your foundation for estate planning, that's that ability to use both of your estate tax exemptions and double them. And so that's always the foundation. So if my estate is suddenly $20 million and I'm looking at a $12 to $14 million exemption range, I need to think right now that's not that I've outgrown my foundation, but what do I have to add to the estate plan that I might not have needed before? So that's an additional building block to do what we call more complex or sophisticated estate planning to take advantage of the exemption that we have today before I lose it. So if I'm at $20 million and I can shelter almost 26 million today, 27 million today. How can I gobble up some of that exemption before it goes away? And that's the more sophisticated planning that you might have to add to your plan.
Talking with Todd Lutsky from the law firm of Cushing and Dolan. The phone number for the studio here, so you can ask Todd your question, is 888-205-2263. Still have another spot or two open, so again, call that number so you can speak to Todd right now about your estate planning questions. 888-205-2263. We're going to take a quick break here, but when we come back, it's right to your questions with Todd. That number one last time is 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. You're listening to Ask Todd with Todd Lutsky on the Financial Exchange Radio Network.
All right, let's get right to your questions for Todd Lutsky. First off, we've got Paul in Connecticut. Paul, what's your question for Todd?
In an irrevocable grantor trust under two scenarios, one is you are subject to estate tax and the other that you are not. How do you facilitate getting step up on the assets given the recent ruling and the lack of clarity on multiple websites from attorneys I've read on that subject of getting step up within a grantor of irrevocable trust?
So this is the confusion, and it's unfortunate that other attorneys don't understand what this revenue ruling says. I'm familiar with it. We've been talking about it for an entire year. It is crystal clear to me that this revenue ruling that you're referring to does not change the rules at all regarding a step up in basis. It's basically confirming the exact same rules that have always existed. Let's go through them. 1, if you have an irrevocable trust, much of which might be one like I talk about, like a Medicaid type irrevocable trust. If you have an irrevocable trust in which you transfer assets but retain the right to, like, the income or the ability to change the beneficiaries of the trust, and you retain that right, then that makes the transfer to the trust an incomplete gift for gift tax purposes. And so 2036 of the code says if you transfer assets to a trust like that, where you retain the right to the income, then for estate tax purposes, that asset will be included in your estate as if you never gave it away. Again, it's going to avoid probate. It's protected from the nursing home. It's doing everything it's supposed to do, but it's not reducing your estate for estate tax purposes. I want inclusion, and that's why in that kind of trust it would be drafted for inclusion. And when it's included in the estate, you get the 1014A step up in basis for sure. Now, to your point, what about a grantor trust that is a completed gift for estate tax purposes? I transfer my asset to the trust and I'm not the trustee. I don't have the right to the income. I've not reserved those powers. I've cut the string, if you will, from that asset. So that asset will no longer be included in my estate when I die, because the desire was to have that reduce my estate and grow outside my estate. Lovely. That's what the goal was. That's what's done. Even though for income tax purposes, I retain a grantor power causing me to be treated for income tax purposes as the owner. But when I die, if it's not included in my estate, I do not get the step up in basis. Whereas that revenue ruling was trying to say, because 1014A is an income tax code section and I'm deemed the owner when I die, that I should get the step up, but it's not included, so you don't get the step up, which is exactly how it has always been. Confusing for some. I hope I cleared it up, because there is and should be no confusion about it. And that said, there's plenty of confusion about potholes to avoid in your estate planning. This could be one of them, right? How do I know which trust is right for me, right? How do I know what to do in my estate plan? This is a guide called Estate Planning Potholes to Avoid. As we near the end of the month, if you've not done your planning, this is for you. It's going to show you things to think about that you might not have thought about going forward, and avoid those potholes as you're going to get your plan in place. If you've done your planning, it's going to show you why you might need to revisit it and maybe change it, right? Please, some of the tips: don't rely on a will, as Chuck said. Don't think you have a nominee realty trust and that's all you need. Maybe I haven't looked at my plan in 10 years. Maybe I moved. Maybe I remarried. All things to think about and how those things impact your plan. It's good for the planner, good for the person who hasn't started their planning. 866-848-5699 or legalexchangeshow.com. You can download it there. Again, 866-848-5699 or legalexchangeshow.com.
Todd, I've got another caller for you. Let's go to Dan in Peabody. Dan, you are on with Todd Lutsky.
Hello, Todd. First, I have to say that my wife passed away in October.
Oh, I'm sorry to hear that.
And we were in the middle of a divorce.
Oh, boy.
Do I have divorce for she had a house, I had a house,
So let me ask you this. I've got to interrupt a minute. So your wife passed away before you completed the divorce?
That's correct.
So you were technically married when she passed?
Absolutely.
So what's your question?
Well, am I entitled to any of her assets?
Was there any kind of estate plan in place on the date of death?
I believe they changed the two kids involved changed the trust that we had.
Prior to the divorce and prior to the death?
That's correct. But she had Parkinson's and Parkinson's dementia.
So you're going to have to see whether or not there's a capacity problem to see whether or not when she changed the trust she had capacity to do that. And you might be able to challenge that to say that was ineffective, right? And of course, it can't be changed after you file for divorce. Once somebody files for divorce, there's an automatic stay on all assets. You can't change things. So you have to check with your divorce lawyer to see when all those dates coincide and how that may or may not impact the plan. But once you find out what the estate plan was, you need to find out what possible agreements were in place regarding the divorce prior to her death, if any. And then you can determine what estate planning documents were in place that were actually effective, and then you got to see what they say. Now, interestingly enough, if you had any jointly held assets on the date of death, those automatically pass to you as the surviving joint owner. So, yeah, I think you would get that. But I'm not sure how that's going to impact the divorce. Obviously, you don't need a divorce anymore. But, that is absolutely one of the potholes that I talk about in an estate plan, right? What if somebody got a divorce? Go back and check your planning. Get it done. That's a pothole, a red flag to remind you of something to do. So in your case, find out what was in place. Challenge something if you think capacity didn't exist when the change was done. Look at the final documents and see how all the other assets were owned on the date of death. It might affect what you're going to get, and then you'll have to deal with the divorce issues later. So hope that helps.
Mr. Lutsky, thank you so much for joining us today.
Always a pleasure. Thank you.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated. Creating the right estate plan to help secure your future takes effort. There are plenty of mistakes that you can make, any one of which could have a dramatic and damaging effect on your financial strategy. Cushing & Dolan are experts in estate planning. Their brand new guide is called Detour Ahead, Estate Planning Blunders to Avoid. In it, you'll learn about these critical errors so that you can make the right decisions to always protect your assets. As an example, if you've created a trust more than 10 years ago and haven't updated it since, you're setting yourself up for problems. Cushing & Dolan's new guide will help you address issues like this. So call right now, 866-848-5699, and ask for your copy of our new free guide called Detour Ahead, Estate Planning Blunders to Avoid. That's 866-848-5699, or request it online from their website, LegalExchangeShow.com. That's LegalExchangeShow.com. The proceeding was paid for and the views expressed are solely those of Cushing & Dolan. Cushing & Dolan and/or Armstrong Advisory may contact you offering legal or investment services. Cushing and Armstrong do not endorse each other and are not affiliated.